Welcome to Working for Women, the Independent Women's Forum podcast, where we are changing the conversation about women and public policy for the better.
Hello, I'm Hadley Heath Manning, Director of Policy at the Independent Women's Forum. Today I'm here with Erin Hawley, an Associate Professor of Law at the University of Missouri and our Legal Fellow at IWF. And today we're going to be discussing Erin's most recent legal brief for IWF, which is titled Rethinking the Administrative State. Welcome, Erin.
Thanks so much for having me, Hadley. Glad to be here.
Sure. So first, before we rethink the administrative state, can you explain for our listeners what that term means? What is or who is the administrative state?
Absolutely. So you do hear this term administrative state sort of bandied about the media, and what it is really referring to is the federal agencies. So if you look at our federal government, there are hundreds of agencies located across the government made up of unelected bureaucrats. And if we look at what these agencies do and what they're made up of, we've got federal employees who perform a whole host of functions. So they're housed within a federal agency, the Environmental Protection Agency for one, Health and Human Services Agency to name another. And these different federal employees have different roles within these agencies. So the administrative, in part, is made up of agencies that promulgate rules and regulations. So this part of an agency will develop the rules that apply. For example, Health and Human Services determines what's required by the Obamacare insurance plans. Federal agencies make up those rules. Other parts of federal agencies actually adjudicate disputes involving those rules. So they will come to a workplace and say, I think we've violated some different OSHA regulations and how your workplace is supposed to function. And so there will be sort of a judicial proceeding that takes place within that agency. And they also have enforcement authority. So you have this vast federal bureaucracy, the administrative state, that's really performing a whole host of functions. And as we'll discuss, that's one of the problems with the administrative state is that you've got rolled up within it federal employees who are writing law, basically. They're writing regulations that have the force of law. Then they are interpreting those regulations to particular cases, to particular individuals and businesses. And then they're also enforcing those regulations against those individuals and businesses. So short answer is that the administrative state is made up of federal agencies, hundreds of those located throughout the federal government. But there's a whole host of responsibilities and powers that are rolled up within the administrative state.
So maybe some of our listeners are listening to this and they're thinking, well, that sounds like a normal thing. I mean, this is the way that it's been for some time now. So why do you argue in this most recent legal brief for IWF that we need to rethink the administrative state? In other words, why should our listeners care about this issue? What's wrong with the way that things are going right now?
I think it's really important to think about the administrative state because we need to think about who it is that is making these sorts of decisions, monumental decisions, many of them for the American people. As the late Justice Scalia said, when you think about the administrative state and administrative deference, the question really is who we are governed by. So is it, as our civics teachers taught us, that we are governed by sort of a tripartite government where it's Congress that makes the law? If you are in conflict with that law, then you're brought into court and you have an Article III judge who adjudicates that dispute. And then, of course, you also have the executive branch who enforces the law or brings that lawsuit. So in order to curtail liberty, in order for government to act against an individual or a business, you need to have each of the three branches, Congress, the executive, and the judicial branch, sort of all play their own constitutional part within that system. But what we have in the administrative branch is all of those powers combined within a single agency. And this is really concerning if we think about the accountability of federal agencies. Most of these employees who are within agencies are unelected. Of course, all of them are unelected, and many of them are unaccountable. There are agencies have some accountability at the highest levels to the executive, but they, of course, are never elected. The people never have a chance to vote on administrators who make the laws that affect or make the regulations with the effective law that affect daily decisions in basically any capacity you can think of. We have a federal regulation that governs that conduct, and yet the American people never really have a chance to say, we're disappointed in that regulation as they can when you've got a law written by Congress. There's less accountability with the administrative state, less transparency, and I think that really is a problem when we think about how we're governed.
Yeah, I remember when I was really young, I used to watch these videos. They were animated, and it was part of the Schoolhouse Rock America series. And one of my favorites was about the three-ring circus, and it compared the three co-equal branches of government to three rings in a circus. And sometimes I think what's happening in D.C. is a lot like a circus, but at least those three branches were designed to have sort of those checks and balances that we learn about in civics class and what you're describing. But I think what's missing, at least in my mind, and maybe with some of the American public, is sort of the history of how we got to where we are today. Because we learn about the founding, and we learn about the design, and we see where we are today, and we see what's happening with the administrative state, who maybe is, messing up this idea of separated powers and checks and balances. But can you explain, how did we get to this point?
Absolutely. And to pick up just for a second on sort of the framers' design, you're absolutely correct. As we've talked a little bit about the three separate spheres, the separated powers means that the framers intended to separate the core governmental powers against three separate and equal branches so that they could check one another, so that this would be liberty enhancing. And I think it's often overlooked when you're talking about the Constitution, how important these structural provisions are, because the framers recognized that there were a number of very good documents purporting to protect individual rights, very much like our own Bill of Rights throughout the world at the time of the founding. They protected things like religious liberty. They said the monarch shall not have absolute power, those sorts of things, protections that you think would be very vital to government. But it turns out that those protections were really worthless unless there was some sort of structural provision to divide power. Because if you have absolute power, then those provisions really are not worth the paper they're written on. So I think the genius of the American Constitution really is in its structure. It's the structure that allows us to preserve the individual freedoms contained within the Bill of Rights. So that's sort of the founders' visions, these separate branches, and again, also separated by the federal government and the state government. So they really wanted to divide up power. But then you see in the progressive period, you see individuals who are really enthusiastic about sort of government by the experts. So their view of government is that we don't really like a Republican form of government in the sense of representing the people. It's actually much more efficient, better if we are governed by experts. So some of these thinkers, Wilson, one, thought that the constitutional constraints on separation of powers really just hindered or limited government. So their view was that we should vest this sort of impartial experts with more power. They even described, combining the executive power, combining the power to formulate these rules, combining the lawmaking power, and combining the judicial power, and wrapping these all up within this one branch in order to make government more efficient. Well, this might make government more efficient. As we see today, Congress can certainly pass a few laws, basically somewhere around 100 substantive laws per year, and then these federal agencies promulgate thousands of substantive regulations that implement these laws. So it might be more efficient if we have sort of experts who are tasked with interpreting and promulgating rules and applying them to individuals. But you do really lose out on that separation of powers, that structural constitution that was crucial to the framers' design. And so I think efficiency might be served in some instances, might not in others, but in all events, it's not a substitute or a reason to discard the structural protection.
You're talking about these experts. And all I can think of are the words from Reagan. He said the 9 most terrifying words are, I'm from the government and I'm here to help. It sounds like
yes.
When you're talking about these experts that are going to govern us, that's what I think about. But another thing that I hear about, it's a term that gets tossed around, and it was actually something that came up in 2014 in a Supreme Court case that was very relevant to the debate over Obamacare and specifically the subsidies that are available to people who buy Obamacare plans. Was the term Chevron deference. And you mentioned Chevron. You actually discuss it in depth in this legal brief that you've written for IWF. So can you explain what Chevron deference is and how it fits into this conversation about the administrative state today?
Absolutely. So Chevron deference comes out of a 1984 case by that same name, Chevron. And in that decision, the Supreme Court sort of laid down a rule for analyzing a regulation. So in the ordinary course, Congress will pass a statute. And now we know since the New Deal and since this progressive sort of revolution, we have administrative agencies who in large part implement that statute by promulgating regulations. Well, what the Supreme Court did in the 1984 case of Chevron was say, well, we're going to sort of assume that if Congress is silent on an issue in a statute, that they intended to delegate that sort of interpretive authority to an agency. So we, as a court, are going to defer to that agency's interpretation of the statute. So that sounds sort of reasonable if we're going to assume that Congress intends for the agencies to implement its policies. If Congress doesn't say anything, then we'll sort of give a broad reins to the agency to implement that policy. But again, this looks a little problematic if we are thinking about the separation of powers, because of course it's for Congress to write the law, not a federal agency who's not even in the Constitution, of course. And so what we have with Chevron deference is we have the court saying, we are not going to interpret the law, which is our duty under Article 3. Instead, we are going to defer to agencies. And this is really key in the face of congressional silence. So what you get with Chevron is if Congress says nothing about an issue, then the courts are required to defer to an agency's interpretation of that issue. So you really have, in that instance, you have Congress that's silent, you have the Supreme Court whose hands are tied in deference, and so it really leaves broad policy discretion to an agency on critical questions of law. Again, something you think might not square exactly with the framers' design.
It sounds like from all that you're describing that we have a problem today with the administrative state simply being too powerful and kind of wrecking this beautiful design that the founders put together for the three co-equal and separate branches of government. So I guess in an effort to end the podcast on a positive note, can you give us some reasons for hope? What can be done about this? Are we just supposed to give up and say, well, nice run, America? Or is there a way to sort of get our government back on track, back closer to this original design?
You know, I think that the Supreme Court really will be an ally in coming years in thinking about how we can reshape the administrative state. The Supreme Court has been sort of practical in acknowledging that a good deal of our government takes place at the administrative level. And in all honesty, that's probably not going to go away tomorrow. But a number of justices have expressed growing concerns with certain aspects of the administrative state. Certain justices are very concerned about the consolidation of all of the government powers within this single agency. Others are concerned particularly about Chevron deference, or this idea that if Congress does nothing, then the federal courts are supposed to let the agencies sort of do what they wish with a regulation. In particular, I think one reason to hope is that the newest justice, Justice Neil Gorsuch, has been particularly outspoken and sort of critical of the idea both of consolidated agency powers and in particular the Chevron doctrine. He wrote a case just a few years ago in 2016, actually, in which he suggested that Chevron deference may be contrary to federal statute. That's the Administrative Procedure Act, which requires the courts to interpret statutes, not to leave that to agencies, and also counter to sort of these foundational principles, the separation of powers ideas that we've been talking about today. So I do think there is reason to hope that the Supreme Court is getting troubled by the breadth and depth of the administrative state today, and I think that Justice Gorsuch will be a keen ally and keenly interested in those sorts of issues at the Supreme Court.
Well, there you go. There's a high note, something to look for and look forward to and be hopeful about. Thank you so much, Erin, for being our guest today on the Independent Women's Forum podcast. To those of you who listen to this podcast, thank you for tuning in. You can read Erin's legal brief on our website, iwf.org. It's called Rethinking the Administrative State. And thanks again, Erin Hawley, for being our guest.
Absolutely. Thank you for having me.
If you enjoyed listening to this podcast, please give it a thumbs up, share it on social media, or stop by iwf.org for similar content.